mine. In fact, it's can be said as a complementary session to whatever we had before also. So I would just share my screen, and I hope I do not face any technical glitches now. Yeah, so my area of presentation is all on experiential legal education and how well it can be integrated into the course. And Professor Nitish and Professor Subair has given us a lot of methodologies in which it can be integrated, which comes very handy. So this is also based on some of my experience that I had with the Canadian institutions about how they integrate the course. So before I go into how, and there was a small empirical conducted to about different categories of colleges having their course integrate the experiential learning. So let me just take you through the conceptualization part. Why particularly? Because there's possibly a high-end possibility that we generally interchangingly use experiential learning and clinical legal education. And as definitely as we have understood in the Indian context, we look at clinical legal education to be the broader concept of including simulation exercises as well. Whereas when the literatures talk about clinical legal education as a mode of having clinics and having a real clients or live experience to the students. So primarily, which might be inculcated through the clinics that we have, the legal clinics, or exposing them to live clients, or as it already mentioned by the previous presenters, of having them involved with social activities and having them be part of projects where they have the experience with the grassroots level issues. Well, it is definitely the situation that we would all want our students to be in. But one of the challenges that we face as academicians or in terms of institution is one, definitely the resource constraint and the time constraint to ensure that we are able to implement it through the 5-year course. Also, the second thing is, I know it's not right to say, but to the extent of recognition that the Bar Council gives to the academia, there again we face certain level of challenges. That is where we have the experiential legal education stepping in to come as an aid in terms of bringing some of the experiences at least to the classroom level. And as Nitish sir has already pointed out, some of the experiences or methodologies that he would, that is being followed in the university would also be referred here. So some of the experiences that the Canadian institution primarily for, because the first wave of the clinical legal education moved in the North American. So I had the opportunity to experience, as in witness some of the practices they had to see how they inculcate into the course. Well, it's not right to compare Canada and India because the methodology, structuring, and the resource is on a different level. So before I go into, I would also like to take you through certain backgrounds, which we're all aware about this, so I do not want to go into this slide, and how the transition of the law course came in. But what was interesting that I noticed was about the number of law colleges in India, and I would like to share the list. As per the Bar Council list given on 2nd April of 2018, was 1,774 college institutes imparting legal education, and they categorized based on the autonomy of deciding the curriculum, especially in terms of clinical legal education, are on 7 levels, right? So what we notice is that, say for instance, a law university, autonomous college, or a department of a private university enjoy a higher level of autonomy while trying to integrate these methodologies. And what is also interesting is that they form actually the minority of the group of institution, because even if a college is a private institution, what happens is they're generally affiliated to a government university. And in such a scenario wherein you are trying to integrate the learning into the course that is being offered, they face certain challenges. For instance, the college I teach is a private college but affiliated to a state law university which has 113 colleges, law colleges alone affiliated to it. So every time we try to make a difference in terms of having it integrated into the course syllabus, one of the challenge is to get an approval from the university. Because one of the, again, a challenge is unless the system goes to be integrated and students are able to take it as part of the curriculum of learning, there would always be a disparity. That is where, as Mahek also pointed out, how when it's voluntary, you definitely have interesting students come forward. And to the limited experience that I've faced, it's always the limited number. So one of the challenges that we again face is the multiple regulatory authorities that a law institute face. Definitely Bar Council providing the benchmark. Then we have the UGC providing the quality of higher education and the respective universities. The moment once you travel through all the bottlenecks and to have it pass it through to the student, this faces a certain level of challenges, right? So one thing that I was keen to understand was definitely I had the opportunity to be a alumni of National Law School of India University, and also to work with a private university affiliated to a government. There was a wide difference, and it's about the entire system goes to a blame game. So the students would say the university or the college is not giving us an opportunity. The faculty would say the students are not enthusiastic to get them involved. The college would say the authorities don't let us to have that. So the entire blame game goes, and there was a claim to have it integrated. All right, so one of the curiosities to meet up was to conduct a study on to see how far the experiential learning was integrated into the course, leaving aside the 4 clinical papers that is already part of the Bar Council regulation. The question here was to see how from the first year, were you given a simulation exercise or were you given an opportunity to be part of a clinical experience? And definitely we had a mix of responses here. So the sample size was determined on the basis of 5% confidential interval, where I had a sample size of around 398, because as they now, though I was not able to complete it totally, which is still in progress to understand how it goes. So the idea was to look at how exactly are these to see how exactly the clinical legal education are apt in its term and not restricted to the experiential learning part of it. As in, where are you exposed to the real clients and having an experience with these clients as in. So what was interesting was very minimal students or the stakeholders. So primarily the stakeholders were divided from the students, alumni, and the faculty members, and then the interviews to be carried out with different institutions, different categories of institution. So one of the things that what was brought to the notice was there was very limited exposure in terms of having the real clients as a mode of their teaching methodology. So we do have clinics, we do have clinical papers, but they were also engaged as simulations. But now what was also the question was to identify was how many of the clinical papers were actually integrated. And what was surprising was, barring certain universities where they enjoyed the autonomy, they primarily follow the lecture method. And that by the time they come to the clinical papers, they face a disconnect. And most of the time it was seen that the clinical papers were treated like a theoretical paper. It's not that students were not exposed to knowledge. It was not that the faculty was not taking the benefit. From this, have a disconnect. On that level, so while looking at the stakeholder interest, what was interesting to see was that majority of the students would prefer an integrated method of learning than to have a dedicated paper in the end. Say, for example, it is brilliant when you have the dedicated papers, because this was actually missing in the Canadian law schools. They did not have dedicated clinical papers. Rather, what they had was something called as a practicum paper. So they would identify certain papers from each semesters and see which are the papers they could take the students to the field. So in that way, they would identify the skills and values that was expected from the law student, attach the skills and values across the semesters, which would also encourage them to stay connected. Now, this was a challenging part to have it as an experiment in India, primarily for the different categories of colleges involved. So some of the things, as I believe the professors before me had also discussed, is to have certain, in fact, the, would you say, the flexibility is to an extent given in the bar council rules as well, to have the assessment of the class based on certain tutorial classes, or have moot court practicals, or in terms of those level. I believe if we can have something of that level, and faculty members are trained through from even from the non-law papers. So one thing I really appreciate about the IP University syllabus was also that the fact that there was a level of experiential learning included into the foundational courses as well. So if there was a possibility of having this distributed rather than have it focused except in the final 2 semesters, and then to have focused experiential learning in papers and have specific clinical papers where they opportunity to interact with clients in terms of having to discuss or provide a client counseling in the presence of experienced lawyers would also give them adequate experience. But this can definitely be completely effective if the bar council takes an initiative to ensure that there's a level of recognition given to the institution in case of dispute resolution. In fact, we have that opportunity where we have mediation centers set up in the institution. In scenarios where we have the ability to set up those mediation centers, we would also have an opportunity to give them the clinical courses in its full sense, and to have the experiential learning, as sir had already pointed out through various methodologies that he has said, to be integrated into the course rather than to just focus it into the final 2 semesters. And here I would, before I conclude, like to take the final words of Professor Mammen, who had put certain different point, especially in his draft legal education policy, of how he would actually would have a restructure to have the basic skills provided in the first 3 years and help the students identify the career interest, and in the final 2 years, I mean, even if it's for the 3-year course, but the 3-year course or the 5-year course, to have the process to be identified in the final year and skills be trained like that. And I believe some of the universities where I was able to interact with have taken off these methodologies to adopt these methodology and ensure the students are trained that way. But again, the challenge still is about how do we support or have universities, affiliated colleges enjoy this liberty. And I believe this is some question which, if as I conclude my session, that we can take at least the remaining 10 minutes for discussion to look at the affiliated colleges and those challenges so that we have a holistic approach to it. Thank you very much. In case of any questions, I would be more than happy to answer. And it would be really nice if we can have a discussion also.
Thank you so much, ma'am, for your wonderful presentation regarding experimental learning. So, ma'am, there are a few things, just a comment I like to say that I have also missed, and you might also be agree that in legal education also there are few things which are important even today, that the administrative hurdles has to be removed altogether, because that seems to be the major area for whatever university where we teach, either it is a public university, either it's a private university also. Brownie points and the administrative interference seems to be the one important area also. And keeping in mind the same thing, the what has been said by the Mammen and the respected Professor Upendra Bakshi, that academic freedom is something which is more important, and I'm sure Nitish must also will agree with the same, that academic freedom, it seems to be a very important area. Then only a teacher, a law student, or a PhD scholar can prosper also. Yes, any comment?
I believe, Nitish sir, are you muted? So if you could unmute yourself.
Yeah, now it's okay. Actually, I was using, a laptop. The battery is down, so I'm using my mobile now. One thing that we can do is, the university always, affiliated college also have always an opportunity where you can create credit courses. one credit course or two credit course, and no doubt these credits are not in terms of because you cannot, there is a well settled rule for you. You cannot actually, student cannot encash these credits, but at least there will be kind of a certificates and things that could be done for them. So you can just fix up some subjects where you have some clinical exercises and all, and you give them a kind of a certification from the university, from your affiliated college, because for that you do not require a permission from university. Even knowledge teas as a certificate course, just having a website and LLP. So for certificate, no problem. For diploma and all, you may require to have a permission from the university. So the best part that you can do and try using all these problems that you say that are the problems, you can get in, sorted out by some credit courses, certificate courses and all, by your own college. And if possible, make them free for the students, because you're already charging money to them. So that will be good for them. Yeah. And regarding academic freedom, most of the time, I always say that I only don't like four things in academics. One is exam duty. Other is question paper setting. Third is copy checking. And the fourth is that some guest is coming, please go and attend. If I really am interested, I'll attend. If I'm not interested, I'll not. So even in my class, if some students are not interested, I'm saying, you will get attendance, you leave. But there is always a fear of missing out in my class that, okay, sir will come, even if he does not teach something very, good, he will be talking about some internship, or he will be talking about some scholarship, or he will be talking about some international conference. So wo miss na ho jaye, is wajah se bacche baithe rehte. So, maybe the quality and content will gradually come with as I'll grow old and my hair's turn gray. But still there is a fear of missing out in my classroom. So most of the time these universities are, everything is like for them is mandatory or deadline is the word for, especially for private colleges, is like हर चीज ही mandatory और हर चीज ही deadline है. And मैं पिछले 5 सालों से गलगोटिया में, before that I was with Nirma, उससे पहले CNLU में था, and I tell you even at National Law School deadline is deadline, वो deadline ही लगा रहता है. But मैंने कभी ज्यादा follow नहीं किया, 1-2 दिन हमेशा late होता. Because there are some always priority, you are going to declare results in 6 months. Why you want the result to be prepared just now today? I always have questions and there is no reply to it. People say that I am very arrogant in terms of the work that I do and I do not take these kind of administrative things seriously. But tell me whether I'm writing a paper for Scopus Journal, whether that is important, or preparing a result is important right now today with a deadline when you are declaring results after 6 months. If you can give me a justification. So I agree with Zubair sir, there is a lot of issue, and Zubair sir, I'm happy to share you that I'm also part of All India Law Teachers Congress. I'm an executive board member. I just got appointed 2 years back. So happy to see another AILTC member here in the conference.
Excellent. Is there anything else you would like to add on? Anyone?
Any of the attendees or listeners can ask any question if there is.
Right. Especially this would, because in fact, while sharing the experience of Indian legal education with the Canadian academicians, my professor there was talking about how they have so many law institutes, and that was 20. And she's saying there are already too many law institutes. So I was like, okay, so what do we do with the 1,700 we have? And she's like, so what do you do with the 1,700? Because for them, I believe it's also time that you start recognizing the academic contributions. Because I was in fact looking at the book, An Idea of a Law School from the Law School. And one of the, constant argument that was put forward was there are different means in which an academia can be involved in the justice delivery system. And most of the time that is underused. And in that case, that disconnect will always be there. In fact, the lawyers community itself is actually creating the disconnect. And if we could actually do something about that, I think we would also have the students also to take the entire system also stronger. Because one of the criticism you face is, yes, it's definitely, you cannot completely prepare them for their profession, but you definitely learn something in the 5 years. 5 years is half a decade. So if you can have some kind of interlinking, a stronger bridge, I think it would definitely be good for the entire system.
Definitely, and the time which has now we are facing, I think the mental distress seems to be one of the important area, not for the law students but for the law teachers as well also.
Yes.
So this is again, and this mental distress is a universal problem for all the law teachers across the world also. I'm sure even all the attendees also will agree with the same also. So we need to cope up with that problem as well also, because this is a long battle. I think the Cambridge Law School has already said that they're going to open after summer 2021. So let's see in our country, in India, how the things will proceed further also.
Brilliant. If there isn't any further questions or queries, then I think it would be we can conclude. So we were not late for the panel discussion following ours, and I believe there are quite a lot of discussions that's lined up for today. And before I conclude, I would like to thank all the presenters and the attendees for the excellent discourse that we had, and especially the Chinese University for actually arranging it in that particular order, because each presenter was actually complementing the other, and there was the overlapping was also avoided to a large extent. Thank you so much, and it was a pleasure to meet academicians from different areas.